From the daily list under heading 4, Judgment Item 1, WPC 6839 of 2023.
Lordship, may I mention one case?
District petition is assessed.
From the supplementary
You
list,
wanted to mention?
Yes. Lordship, this is a criminal revision, Lordship. In this case, the trial court is not granting the petitioner to file the discharge, Lordship. We have already, yes, Lordship, we have already filed the criminal revision, Lordship.
See, mentioning is your matter of right. You want it tomorrow?
Yes,
Post tomorrow.
as your Lordship.
You need to mention all the matters before the court master. He has been instructed to allow all the cases, all the mentions by default. In order to reject, he has to come to you.
Petitioner has filed the writ petition for grant of 4th DSCP. Petitioner is a medical officer who has completed more than 25 years of service. On 19/3/2013, on that day, there is no departmental or criminal proceeding pending against him. My writ petition is pending before.
Consider his representation. Maybe that there is a departmental proceeding subsequently, but we do not know. As per your rules, you have to see whether he was entitled on the particular date he can entitle. You have to consider the rules. There is no adverse order.
No.
The learned counsel for the parties are present. District petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner at the relevant point of time was eligible for grant of 4th DSCP, and on the date of his entitlement there was no departmental or criminal proceedings pending against the petitioner. He has submitted that with regard to the aforesaid relief, the petitioner has filed representation before
Respondent number 2.
respondent number 2, but no adverse order, but no decision has been taken. And therefore the petitioner is seeking a mandamus from this court. The learned counsel for the respondents has submitted that the matter can be looked into by respondent number 2 in the light of applicable rules and guidelines, and therefore this petition may be disposed of. After hearing the learned counsel for the parties and considering the nature of relief sought for by the petitioner, this court finds that no adverse order as such has been placed on record by the petitioner, though no counter affidavit has been filed in the present case. Considering the nature of relief, this petition is disposed of, entitling the petitioner to approach the respondent number 2 by filing a detailed representation in connection with his grievance with supporting documents, and also a copy of the records within a period of 15 days from today. Upon filing of such representation, the respondent number 2 is directed to grant an opportunity of hearing to the petitioner and pass appropriate reasoned order by taking into consideration the applicable rules, guidelines, etc. as may be to the applicable rules, guidelines, etc. The reasoned order be passed within a period of 4 weeks from the date of the representation and be communicated to the petitioner to speak first. If the petitioner is found entitled for any monetary benefit out of the reasoned order, the respondent number 2 shall take appropriate steps so that the same is also remitted to the petitioner within a period of 6 months from the date of disposal of the representation. That's it. The state petition is accordingly disposed of.
Item 2, WPS 7146 of 2023.
Yeah, we also.
Yes.
The respondent.
You have attained the age of superannuation.
Yes,
This has become infructuous.
no, but if the because the petitioner has approached the concerned authority, and the concerned authority has
When did he approach?
she approached by annexure 2, Your Lordship. I have annexed, and on 2022, Your Lordship. But without
At the
consenting.
fag end of her service tenure.
Yes, Your Lordship. Because being a illiterate lady, she got only so
Please don't.
category 1.
No. She is in government service, you can't say she's in.
So, without considering her the annexure 1, Your Lordship, they have passed the annexure 3. Just mechanically manner, Your Lordship.
Lordship, Lordship, she has retired, Your Lordship, on the same month, Your Lordship. In the last fag end, Your Lordship, she has filed this writ petition at the time of, and she has never opposed to the recordings that has been made in the our records, Your Lordship. Her appointment, Your Lordship, was 2001, and the date of superannuation was on 31st of December 2023, and in the month of December itself, this for the first time this writ petition has been filed, Your Lordship.
Any judgment?
The judgment, Your Lordship, I have not come today with the judgment. There was a direction for filing counter affidavit, Your Lordship, that has not been filed, Your Lordship. We can file the counter affidavit, Your Lordship.
The learned counsel for the parties are present. The learned counsel for the respondents submit that the petition has already attained the age of superannuation and the dispute in connection with date of birth has been raised at the fag end of her service career. Considering the nature of dispute, the parties are the counsel for the parties may examine the judgment passed by the Honorable Supreme Court in Civil Appeal number 1009 of 2020 within bracket Bharat Coking Co Limited versus Shyam Kishore Singh, decided on 5/2/2020, which may have a bearing in the matter. Vote this case tomorrow. Next.
Tomorrow.
We can't pass an order without putting you to notice on the judgment, and you are not aware of the judgment. You don't bring the judgments.
Item 3 WPS 7152 of 2023.
WPS number 7152 of 2023. Yes. Counsel for the parties are present. Counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case by 6th of March. By 6th of March 24. Rejoined and reviewed by 13. Post on 20th March 24 under the heading of petition.
From daily list under heading for final disposal, item 2, criminal division 4/2 of 2022 along with item 3.
Where is the petitioner? This passport.
Item 5, criminal division 63 of 2022.
Where is the petitioner?
Under heading for orders, final disposal matters, item 6, criminal division 830 of 2022.
opposite party number 2, my lord. I have filed an IA application for vacating the interim order granted on 28 September 2022.
The matter is otherwise ready.
Matter is
Where is the
otherwise.
petitioner? Will be the matter. So big deal. Where is the petitioner? Absent. What happened in mediation?
Mediation was successful. It was held in the mediation. Mediation was held in the month of October 2023. The parties decided that they will live apart, and a one-time settlement of rupees 6 lakhs, which has to be given in 3 equal installments. First installment is to be paid when quashing application, which is under section 498, they will file. When the matter will be quashed, FIR, they will give 2 lakhs. Second installment, when the
First step has been taken.
no step has been taken for the last 4 months in spite of our repeated requests. And they have, in spite of coming to the agreed settlement before the mediation, jointly signed by both the parties, their counsels, they are not honoring the settlement. They have no intention. And therefore, this has prompted us to come before this honorable court that we are not getting maintenance amount also, since the operation of the impugned order has.
Have you received 50,000 rupees?
Yes, 50,000 I have received. They have come, they have challenged before they have filed this revision, they have challenged the order by which the area of maintenance was ordered to be paid within 1 month, otherwise distress warrant will be issued. They have challenged that order. 1,08,000 was the arrears of maintenance. Again,
When it comes. बाहर जाके वीडियो में देखते रहते, right? I know.
दूसरा कोड
I specialize to see outside. हाँ बोलिए. Yes.
इसमें वो जो मेडिएशन हुआ था
No, it has failed because we are not taking any step.
तो उसके बाद
There was a direction to pay 6 lakhs rupees.
हाँ yes.
There was a time frame also prescribed. You have not taken any steps as per the time frame. So, and there is no joint compromise merely because there is a mediation that is not sufficient.
हाँ मेडिएशन के बाद ही हुआ था उसमें, और इसके बाद जो है कि हमें मेरा कोई इंस्ट्रक्शन है नहीं, क्लाइंट हम डिस्कनेक्ट हो गए किसी
Then
तरह
I will dismiss the case. Criminal Division number 830 of 2022. The counsel for the petition.
ऑन मेरिट लॉर्डशिप इट में
No. You don't have any instructions. It will be dismissed for default. Or maybe
डिफॉल्ट
that
में तो जो हम लोग पे आ जाना है, हम तो फिर मेरिट पे बहस कर
you
देंगे।
argue?
हाँ मेरिट पे
Please
बहस।
argue your case. Because as of now there is no
No.
settlement. Please argue.
First of all, lordship, the IA has been filed.
You forget about the idea. You argue the main case.
Yes.
Which is sent you not
Lordship, that is page 29 notes.
read it.
Yes.
There
This
was a
lordship,
mediation for 9,000 maintenance.
yes, lordship. वो सिर्फ मुझे वही हम पढ़ दे रहे हैं शुरू से. Brief fact is that the petitioner wife Riya Sinha, Prerna Sinha filed this maintenance case on 23/12/2020. First order sheet was drawn upon 2/1/2021. This maintenance case was sent for a special mediation drive in March 2021 under letter number 861 dated 26/3/2021. The mediator reported successfully mediation inter alia that parties agreed at ₹9,000 per month as maintenance. The petitioner wife was present in mediation while OP husband Gaurav Raj Srivastav participated in mediation through WhatsApp. यही मेरा ग्राउंड भी है कि WhatsApp पे जो है कि बात हुआ. Since it was COVID-19, his consent through WhatsApp mobile number so and so was obtained. Print out of same was made part of mediation settlement document. Successful mediation report was seen by this court on 31/3/2021 and by virtue of same, this case was disposed of on 31/3/2021. Thereafter, the petitioner wife filed one petition that in spite of mediation settlement and order dated 31/3/2021 of this court, the OP husband has not been paying maintenance. Notice was issued upon OP by order dated 8/2/2022. OP husband appeared and filed one show cause on 14/2/2022, saying it is not a show cause as against the prayer for recovery of arrear maintenance. Rather, it was prepared as if the original maintenance case is contested, whereas the original maintenance case already been disposed of as aforesaid. On 16/4/2022, the petitioner made clear that a sum of rupees 1,08,000 only is lying due till March 2022. Had both the side. Learned advocate for opposite husband argued that in the mediation the proper and legal protocols were not maintained. Neither OP nor his counsel was present
Yes,
at
we
the
have read
time.
it.
हाँ, सिर्फ इतना यही है, मेन ग्राउंड भी
You
यही
are in a
है.
division
क्या
of
है?
jurisdiction.
हाँ,
You assail, you just point out the illegality or perversity in the agreement.
हाँ, वही कि मीडिएशन में व्हाट्सएप के द्वारा जो है सिर्फ बात हुआ था, ना हम अपीयर हुए ना मेरा काउंसिल है. Only on that basis the mediation report has been submitted. That mediation has been successfully between the parties and therefore the 9,000 rupees. अब यही मेरा ग्राउंड्स भी कि ना हम वहाँ प्रेजेंट थे, ना मेरे बिहाफ में कोई एडवोकेट वहाँ प्रेजेंट थे, और मेडिसिन रिपोर्ट हैज बीन सबमिटेड. यही मेरा ग्राउंड है. यस प्लीज.
For the learned counsel for the parties, this petition has been filed challenging the order dated 17/5/2022 passed by learned principal judge Family Court Hazaribagh, arising out of maintenance case number 142 of 2020, whereby the learned judge has been pleased to direct the petitioner to pay arrear maintenance from 31/3/2021 at the rate of rupees 9,000 per month till date within a period of a month, failing which distress warrant will be issued. It is a case of the petitioner that the original maintenance case was disposed of in absence of the petitioner.
यस. और वो एनेक्स 2 भी यूजर लगाया हुआ है मेडिसिन का. मैं
The
ऑप्शन
learned counsel for the petitioner has submitted that the mediation in the matrimonial in the maintenance case was not properly conducted and he was not assisted by any counsel, and therefore the impugned order calls for interference. The learned counsel appearing on behalf of the opposite party, number 2, has opposed the prayer and has submitted that the impugned order is a well-reasoned order which does not call for any interference. He has submitted that the maintenance case was disposed of on 31/3/2021, and the said order was never challenged by the petitioner. The impugned order is essentially an order of execution arising out of the original maintenance case, right?
Yes.
After hearing the learned counsel for the parties, this court finds that the maintenance case, the original maintenance case number 142 of 2020, was filed by the wife and was sent for mediation. Consequently, a mediation report by letter number 861 dated 26/3/2021 was submitted, reporting that the mediation was successful and the parties had agreed for the maintenance amount of rupees 9,000 per month. further appears that on the basis of successful mediation, the maintenance case was disposed of by order dated 31/3/2021. Admittedly, the said order dated 31/3/2021 disposing of the mediation case was never challenged by the Commission. Thereafter, the opposite party number 2 filed one petition before the learned court below, saying that in spite of mediation settlement and order dated 31/3/2021, the present petitioner was not paying her maintenance. Notice was issued to the present petitioner by the order dated 8/2/2022 to file his show cause dated 14/2/2022. And contested the petition. The learned family court dismissed the show cause filed by the petitioner by clearly recording that the petitioner did not ever challenge the successful mediation report/award in any way, in any legal way. He did not assail the final order dated 31/3/2021 of the court, whereby special mediation report was accepted and the case was disposed of. The findings of the learned family court is quoted as under. Just quote the last portion from page number 30, running page 30. I'll just take it. It's a small paragraph. This court finds that admittedly the petitioner never challenged the final order dated 31/3/2021, whereby the mediation report was accepted and the case was disposed of. And therefore, there is a binding order against the petitioner which remained unchallenged, whereby the petitioner was to pay maintenance at the rate of ₹9,000 per month to the opposite party number 2. This court finds no illegality or perversity in the interim order, and therefore the present petition is dismissed. Interim order vacated. Let this order be immediately communicated to the learned. Council for the state discussed.
Under heading for orders, item 27, criminal revision 264 of 2023.
Pass over in this case. I prefer to start pass over. This was the matter.
Provision being expired.
Not expired, Your Lordship. Before expiry, Your Lordship, it was extended by the Honorable Court, Your Lordship.
Extended till the next date.
Till the next date, and again it was extended till the next date, Your Lordship. It's against 6 month
Now you
conviction.
surrender.
Against 6 months.
Now you surrender.
It will be pass over, Your Lordship.
Without any petition, it was extended. You filed any petition for extension.
No, but it was not expired after it should happen as a
Without
technically
any petition.
technically
There
there
is no
should
petition on
no,
record
there,
also today
no,
also.
there is-
You immediately surrender. We will not hear it like this.
Item 28, criminal revision 298
It will be taken
2023.
up. If you don't come, I'll dismiss
no,
it.
I'll
And you remind me before I rise.
then 12
Because one or two times it has
Well-
happened. I will take pass over and then you are absent.
No, I have never been such. Last date, your lordship, I
Ensure
was.
that I
Last
take
date, your lordship, I taken was for 1 hour. I was sitting here only, your lordship, for this case. I
You are
never
a
do
sincere
that, your
person,
lordship.
but your client is not a sincere person. Yes, this, who is appearing?
Item 28.
Petitioner. Let it be passed. In all the cases where the counsel is not appearing, we will appoint amicus and then dispose of it.
Under heading for fresh filing, item 29 WPC 4534 of 2023.
Yes, petitioner.
Madam, this matter I am appearing for on behalf of the petitioner. Short pass over may be given my lordship in this matter. Highly not available.
Also, file is not available.
I have actually Munshi.
Under heading for admission, item 30 criminal revision 424 of 2020.
Our court record has come. So I want just a copy of the lower court record.
You can take, you can have certified copies.
Paper book.
There is no concept, no requirement of paper in revision operations. How busy are you today? Yes?
Not so much.
Not so. So records are here, you go through the record, you can hear it. NI Act. There is OP number 2.
On the last occasion, he has taken time.
If he doesn't come, we can dispose of the matter. There is no problem about it. What is the matter?
Matter is the opposite
You
party.
can do it in the second half also, there is no problem. Yes? You are, who are you?
Check was issued to me, and it was because of insufficient fund. It was lost. This is the case.
Timelines followed.
Yes.
So what is your case?
My case, he has not paid me the money. Despite he was convicted by the first court, and thereafter he moved in appeal, and the conviction was set aside.
Conviction was set aside.
Yes.
That order is under challenge. What is the ground for setting aside?
There are two grounds that the bills which were produced before the court, he has supplied some items, and the bills which were produced before the court was not reasonable according to the court's order.
Reasonable. How will the court determine bill is reasonable? Bills were genuine?
Bills are genuine. As per the evidence, bills are genuine. This is the first round, and second round that this such cases should be tried in summons in summary cases. In spite of that, the first court has tried the case as a summon case. So it should be tried as this time.
Are you there for the bank?
Yes, item 29. In item 29.
just now my lord has passed.
How is this is the case? This one?
Tarkeswar Tripathi, item 29, but I am there in the previous.
How does that make a difference?
जैसे भी
Where
हुआ
is the state council in this case? Are you there, Mr. Agarwal? Are you appearing? Are you appearing in this case? Where is the state council? All the invoices does not depict the actual transaction and are unbelievable. Are you there?
Yes, Milord.
For OP number 2.
No, Milord, I for the state, Milord.
OP number 2 is not appearing.
Yes, Milord. There's a due to 2023 as well, a last opportunity has been given, Milord. It's not appearing.
Let him not appear, we will decide the case.
That's all, please.
He wants to see the LCR.
we'll post it in next week.
Next week is too long. We don't know tomorrow also. You can be posted tomorrow. I have seen it. You see it during the day. Be fresh in your mind. You can flag anything which you want to draw our attention to. You can number it also. 1, 2, 3, 4. That can be taken care of. Or we dispose it of.
Monday, Milord, as always.
No, Monday is
Tomorrow.
no.
Monday, yeah.
Learned counsel for the petitioner and state are present. Nobody appears on behalf of opposite party. The learned counsel for the petitioner submits that the order of the learned trial court has been set aside by the appellate court. By recording that all the invoices do not depict the actual transaction and are unbelievable.
Other point is summons and separated.
We'll see that. There are a few other points also. He submits that the learned appellate court has that is sufficient. He submits that he has to go to the records received from the court concerned.
Yes, yes.
under heading for Who is Akash Kumar Lal, do you know him?
Item 31, criminal division
In
4.
item 29, my lord, I was appearing for the bank loan respondent 3 and
It can't be like this. It has been passed over.
oh,
over as
much. Then I will
12 o'clock, pass over matters at 12.
12. Okay.
Item 31.
Yes, petition.
The instant revision has been filed against the order of maintenance for rupees 8,000 per month to the opposite party number 2. The main ground involved in this case, my lord, I have a only single ground that without any sufficient reasons he has been living separately from me, which transpired from the judgment itself. Kindly see, my lord,
That is only ground.
yes, my lord, without any sufficient reasons he is living separately.
Notice has been issued to the OP number.
Yes, my lord, opposite party has been
Who is
appeared.
appearing for OP number 3?
Some Mr. Thakur is there.
Shashikant Thakur. Anyways, let us see.
Kindly see, my lord, page number 13. Second page of judgment. From para to pardon, but from para to I am reading. Previous page, Lord. The fact of the case as summarized proceeded in the manner that marriage of the appellant was solemnized with the opposite party as per Hindu rites and ritual on 6/5/17, Lord. Kindly date may be seen, Lord. 6/5/17. In the marriage, her parents gave cash of rupees 12 lakhs and ornament for rupees 5 lakhs. And OP number 2, after marriage, the applicant went to her matrimonial house and lived there happily for 10 days. Thereafter, her husband and his parents subjected to the appellant to mental as well as physical cruelty and making demand of rupees 10 lakhs and threatened that if the aforesaid demand will not be fulfilled, she will not be permitted to stay at his house. Ultimately, on 17/5/17, the opposite party and its family members drove him away from his house. 10 days is 17/5/17, 10th day. And she is saying that for 10 days she was living happily.
That is not sufficient.
Lord, she herself stated that for 10 days she was living there happily. Subsequently, she was ousted and there was no contact at all with the petitioner. And she is suffering from schizophrenia, Lord, and unable to enjoy the conjugal life. On that ground, the divorce has been allowed by the court below, Lord.
Divorce has been allowed?
Yes, Lord. On the ground of cruelty.
Permanent alimony has been fixed.
No, Lord, it was contested by the opposite party number 2.
That's right. But still,
The
permanent
same was
alimony
allowed.
has to be there.
The same was allowed by the court below. Kindly see the order of divorce also, Lord.
That's right. But permanent alimony is normally fixed.
Now, that is not decided, Lord, in the divorce case. But after OP number 2 contested the case and the cruelty was proved against her. She was a cruel, it was proved. And that is why the divorce was allowed in my favor. That is below page number 26.
It's expected.
No,
Yes.
contested. Page number 26, which is the order of the divorce, Lord. Para 10, if your lordship permits, I permit to read the same.
So you are declared as mentally insane.
Yes. It was not declared, it was one of the ground to get divorced and she was unable and she was, it was proved that she was doing cruelty with me. She was not enjoying conjugal life, she was unable to. And on that ground, the same was considered as a cruelty and the divorce was allowed. And she has never challenged that order.
That's right. So there is no order of permanent alimony. According to you, she is mentally unsound.
And without any sufficient reason, she has left the matrimony. Not only she, all the parties have stated the same fact.
When was the order of maintenance passed?
The page number starts from page number 12, Lord. 12 to 18.
10/3/20, right?
Yes, Lord.
You see, there is an order of maintenance. There is no order of permanent alignment, right? And there is a divorce, tentative at the same time when the
Yes.
So the point would be whether she would be entitled to maintenance even after the divorce.
She is entitled. As per law, she is entitled.
She is entitled.
But, Lord, so far my case is concerned, Lord, if there is one clause of 125 also, if the wife is living separately without any sufficient ground, she is not entitled for maintenance.
Did you file any petition for restitution of conjugal rights?
No.
Did you make any effort? Because you yourself say that she is mentally unsound.
Yes, Lord.
So effort should have come from your side only.
That is why I filed the divorce petition,
You
Lord.
filed a
Because,
divorce petition on the ground of mental insanity, not on the ground of desertion.
yes,
Ground of divorce was not desertion. It was
Both-
cruelty because she was mentally unsound.
no, both the grounds were there, Lord.
Desertion is
Because
not there.
no, both the grounds were there.
Desertion is not there
Yes.
in the divorce. And otherwise also, just a moment, otherwise also, the impugned order,
So for the impugned order is concerned, Lord, that is the separate ground which relates to the divorce, whether the money should be paid or not.
that
She
is a
should
separate
have-
ground and you
she
have to
should
take
have been
appropriate
challenged.
steps, we do not know.
Yeah.
But so far as this order of maintenance is concerned,
Yes.
there is no illegality in this order.
But Lord, where is the ground that she was subjected to cruelty? She has stated that she was subjected to cruelty for demand of divorce. But
125 CRPC. So, Mr. LCR. LCR. What is the name of the wife?
Shikha Suman. Shikha Suman.
She was examined as PW.
PW. Naming is not been given, but only statement has been given. In which serial it is not mentioned. Gawah Sankhya, yes, Lord. Through the pen it is mentioned. Witness number 2. Pardon, Lord, not
Yeah.
Pardon, Lord. That is not witness. Witness number 4, Lord.
Leader evidence.
Yes, Lord. या कि मैं
Just Prakash Kumar is the father.
देवेंद्र प्रसाद यादव इस बारे में PW3 is the father blood.
PW4. Readers.
यह कि मैं उपरोक्त पति की निवासी हूँ, यह कि मेरी शादी हिंदू रीति रिवाज के अनुसार दिनांक 6/5/17 को मेरे उपयुक्त निवास स्थान 62 बंगलो स्वर्ण साहेबगंज में वरुण कुमार विपक्षी के साथ हुआ था। यह कि मैं आवेदिका शिखा सुमन हूँ, मुझे शादी के दूसरे दिन यानी 7/5/17 दिन रविवार को मेरे पति वरुण कुमार मुझे अपने घर ले गए, मैं अपने ससुराल गई। यह कि उपरोक्त विवाह में मेरे माता पिता ने 12 लाख रुपए और 7 भर सोने के जेवर, नाक, कान एवं मंगटिका दिया था, कुल 5 लाख का जेवर दिया था। यह कि मैं शपथकर्ता आवेदिका का घोषणा करती हूँ कि शादी के बाद मैं कुल 10 दिनों तक अपने ससुराल में रही। यह हिंदू धर्म के अनुसार 10 दिन रहने के बाद मैं 11वां दिन यानी 17/5/17 को मेरे पति वरुण कुमार विपक्षी दोनों पति पत्नी विदा होकर मायके चली आई एवं दिनांक 18/5/17 को मैं शपथकर्ता को छोड़कर विपक्षी वरुण कुमार अपने अनजाने कार्य हेतु कचरापाड़ा गया, यह कहकर कि एक सप्ताह में आकर विदा कराकर ले जाएंगे। यह कि वर्तमान में विपक्षी वरुण कुमार कचरापाड़ा रेलवे वर्कशॉप में पेंट्री शॉप नंबर 9 में कार्यरत हैं। यह कि मैं शपथ कर
She has deposed that there was a torture and demand of dowry.
Yes.
There is no cross-examination.
Yes, bro.
So?
But she has, in her statement, she also stated that she was.
You forget it. You say that there was no reason for her to leave the matrimonial house.
But Lord.
And the reason which she has cited.
Yes.
Was that.
But how can it be possible, Lord, that she has lived? She was stayed at her matrimonial for only 10 days, and she has stated that she was living happily for 10 days. So when she was subjected to cruelty, subsequently she was. Yes, Lord. Yes, Lord. That's all, God.
The counsel for the petition is present. आप statement करें. What do you have to say?
Fight between husband and wife.
The learned counsel for the state has submitted that the state has nothing to say in this matter, as the fight is between the husband and wife. Nobody appears on behalf of opposite party. The learned counsel for the petitioner wife. This petition has been filed challenging the order dated 10/3/2022, passed in original maintenance number 147 of 2018 by the learned Principal Judge Family Court Sahibanj, whereby the petition has been directed to pay ₹8,000 as maintenance to opposite party number 2 from the date of filing of the case, and also directed that petitioner shall pay the amount of monthly maintenance on or before 15th calendar day of every succeeding month to the applicant. The arrear amount of maintenance allowance from the date of presenting of the case till the month of March 2022 was directed to be paid by the petitioner within 6 months from the date of the judgment in connection with original maintenance case number 147 of 2018. The learned counsel for the petitioner, while assailing the impugned order, has submitted that the impugned order is perverse inasmuch as there was no sufficient ground for the opposite party number 2 to leave her matrimonial home. He submits that the date of marriage was 6/5/2017 and she herself reports that she lived happily for 10 days. And thereafter she left the matrimonial home on 17/5/2017. And under such circumstances, the allegation that the petitioner, that opposite party number 2 was subjected to physical and mental cruelty on account of demand of dowry of rupees 10 lakhs is not sustainable in the eyes of law and is self-contradictory to the version of it.
Yes. One more is regarding divorce.
The learned counsel has also submitted that the petitioner had also filed a suit for dissolution of marriage, which was numbered as matrimonial case number 136 of 2018, and the marriage between the parties has been dissolved by virtue of a decree dated 12/1/2022. The inter alia on the ground that the opposite party number 2 was mentally unsound and the petitioner suffered mental cruelty. The decree for divorce as well as a judgment dissolution of marriage has been filed along with this petition, which indicates that the suit was instituted on 2/7/2018. Before the court of Principal Judge, Family Court, Bhagalpur. The learned counsel has submitted that the decree of divorce has become final.
Yes. As per my information.
Your information or your client's information?
Yes. Clients, I have been informed.
And he has been informed by his client that he has not received any notice challenging the decree of divorce.
Yes.
Upon a query of this court, the learned counsel has submitted that no permanent alimony has been fixed in the decree for divorce. Right?
Yes.
During the course of argument, the learned counsel has placed the evidence of the opposite party number 2, who was examined as PW4, and was also cross-examined before the learned family. After hearing the learned counsel for the petitioner and the state, and the state is not saying anything. Learned counsel for the petitioner. This court finds that the sole point which has been argued by the petitioner is that there was no reasonable ground for the opposite party number 2 to leave her matrimonial home, in as much as she had lived in the matrimonial home happily for 10 years, and immediately upon expiry of 10 years she left the house. It is not in dispute that marriage between the parties was solemnized on 6/5/2017 as per Hindu rites, and the opposite party number 2 went to a matrimonial home
on 7th.
She lived in the matrimonial house for 10 days. And on 17/5/2017, she left the matrimonial house the opposite party number 2 in her evidence has stated in paragraph 10 that on this after the second and on the second and third day of marriage, till the second and third day of marriage, the opposite party number 2 was properly treated and during the period from 9th to 16th, the parents and brother of the petitioner started asking her to bring rupees 10 lakhs and consequently she was subjected to mental and physical torture which was untolerable to her. She has stated in her evidence that at the time of marriage, rupees 12 lakhs and jewelry and other items worth rupees 5 lakhs was given. And the petitioner and their family member had not even given her the cash amount which was received in gift and other items which she received during marriage. And the petitioner, under the influence of his brother, left the complainant to her parents' house. And thereafter, the petitioner did not make any contact. This court finds that the complainant was cross-examined by the petitioner and no such question in connection with the aforesaid allegation made by the complainant has been put to the complainant, and the reason for living separately, that is torture on account of demand of dowry, remained uncontroverted. This court is of the considered view that the allegation made by opposite party number 2 regarding demand of dowry and torture on account of non-payment was sufficiently established by the opposite party number 2, and consequently the opposite party number 2 had sufficient reason to leave her matrimonial home. This court is of the considered view that the impugn order whereby the maintenance amount has been fixed does not suffer from any illegality on the ground which has been argued by the petitioner before this court. And accordingly, before this court, so far as the divorce decree granted in matrimonial case number 136 of 2018 by the family court, court of Principal Judge Family Court Bhagalpur is concerned, the same has no bearing so far as the legality and validity of the impugn order dated 10th March 2022 is concerned. and accordingly the present petition and this court finds no reason to interfere with the interim order under revision jurisdiction, and accordingly this petition is dismissed.
Item 32, criminal revision 524 of 2022.
In view of previous order merits, the matter was referred for before the answer merits. Perhaps a report has come.
Your Worship, as per the instruction which I have received, only once petitioner
We are
appeared.
not concerned, we are not going
Your
to
Worship.
force mediation on anybody. To argue the case.
Your Worship. He did, I wanted to submit that he did not comply the court's order. Your Worship.
Which order he did not comply?
The mediation. He appeared only once and thereafter he opted not to go there.
You cannot
Your
force
Worship.
anybody to appear
Your
in
Worship.
mediation. To argue the case only.
Your Worship.
My lords, in this case, my lords, we have challenged the order dated 10/3/2022.
What is your ground?
Actually, my lords, this petition, OP herself doesn't want to live with this petitioner, and if her behavior towards the family member as well as the petitioner
What is the date of marriage?
marriage is of 2016, that is 12/7/2016.
12/7/2016.
My lords. And after that, my lords, he herself left my house, and for that, my lords, we have filed a suit under Section 9 of the Hindu Marriage Act. It was filed and decided in 2020. I have annexed.
When did you file it?
Just a minute. In March 2020, my lords.
March 2020. And when
Sorry,
was this?
my lords. Order is of.
When did you file it?
I have got the copy of this. It is of 2020 minutes. Not adject. I have annex here in the judgment of that very case. That is annex 2 at page 24 minutes. It was decided in the month of February 2020. But in spite of that, my lords, she is unable to comply that very order, my lords. And after that,
It was an ex parte order.
It's an ex parte order. And after that, my lords, she has filed this urgent application, my lords. In which although the petitioner was appeared, but he was debarred to file his so cause. And
When were you debarred from filing? Where is the LCR? Not yet come.
perhaps
No? The learned counsel for the parties are present. In order to adjudicate the present case, let the records of original maintenance case number 60 of 2015 be called for from the court of learned principal judge family court Sahib, which has been disposed of by judgment dated 10/3/2020.
10/3/2020.
Let this order be communicated to us.
Your Worship.
This goes on, is on after 2 weeks, I just give it.
Minutes.
March 24 under the heading for final disposal. What about the interim? Is there any interim order
No,
for
no.
making payment?
No.
Your Worship, he has not paid even a single penny, and Your Lordship, she has one child, and they are forced to reside in her parents' house. Even interim protection is there, Your Lordship, regarding the mediation. He appeared only once. Even 1,000 rupees had to be paid for the traveling allowances, Your Lordship. That has also not been paid, Your Lordship.
You have not paid the travel?
No.
The situation has become very tight, my lords, and by the order dated 10/8/2022, my lords, although this court has granted
You were supposed to appear on 18 July 23. Did you appear or you did not appear?
on the very first occasion, my lords, we have appeared, but
And then you were supposed to pay rupees 1,000 to open the
perhaps that although, my lords, we have got no instruction on that very
The
aspect.
moment we ask you anything, you say you have no
No,
instruction.
for that purpose,
You
my
made
lords.
this around.
As your lordship, we will try to our best to inform the parties regarding the payment of that very
Your Lordship,
amount.
interim order may be vacated, Your Lordship.
If you don't pay it within 1 week, the interim order will be vacated.
Let it be posted on 14th on that very occasion. We will clear up in all aspects.
And this counsel for the opposite party number 2 has submitted that the matter was sent for mediation and the specific order was passed by this court dated 30/6/2023.
On every occasion, my client appeared, Your Lordship.
That a sum of rupees 1,000 was to be paid to the opposite party number 2 for participating in the process of mediation and for travelling and other expenses on each and every day. But not even a penny has been paid to the petitioner.
Although she used to
As per
reside
the
at
mediation report dated 29/8/2023, it has been recorded that the petitioner and opposite party number 2 appeared before the mediation center on 18/7/2023 and the petitioner paid rupees 1,000 to opposite party number 2. Thereafter on 28/7/2023, both of them appeared, but the petitioner did not pay any money. On 11/8/2023 and 21/8/2023, the petitioner was absent, but the OP number 2 was present. On 24/8/2023, both were present. And on 28/8/2023, the petitioner was absent, but opposite party was present. On 29/8/23, both were present. It appears from the mediation report that the opposite party number 2 had participated, had appeared before for purposes of mediation on 18/7/23, in fact, for it rupees 1,000 was paid to the opposite party. That it is 28/7/23, within bracket, no money was paid to opposite party number 2, semicolon. On 11/8/23 and 21/8/23, the petitioner was absent, but OP number 2 was present. And thus on 11/8/23 and 21/8/23, apparently no money was paid to the opposite party number 2. On 24/8/23, both of them were present. And it is not clear from the mediation report as to whether any amount was paid to the opposite party number 2 on 24/8/23. On 28/8/23, the petitioner 28.8.2023 also, no money was paid to the opposite party.
सिर्फ 3 साल का बच्चा को लेके दिन भर वेट की और ये इंटेंशनली अपीयर नहीं विथ पेरेंट्स.
Counsel for the petitioner is directed to seek instructions and file a supplementary affidavit in the meantime by next Thursday with regard to the payment to the opposite party number 2 for participation in the litigation in terms of the orders passed by the Supreme Court. From the records of this case, it further appears that on 14/2/2023, both the parties were to remain present before the mediation center on 27 February 2023, and the petitioner was directed to pay a sum of ₹2,500 to the opposite party number 2 for traveling and other expenses on each and every day of mediation. There are two different orders. One is 1,000 rupees. One order on 36/23 and one order on 14/2/23. However, on 36/2023, the traveling and other expenses has been mentioned as ₹5,000. You file your affidavit. For the purposes of considering the affidavit of the petitioner, post this case on next Friday. In case the so that appropriate order can be passed on the interim relief which has been passed by this court.
Lord, so distress warrant have been issued against him.
This
So
will have been vacated. We are just giving him an opportunity.
So far the interim order is concerned, my Lord, sir, it was granted on 10/8/2022 with a condition to deposit a sum of ₹50,000 that we are unable to deposit it. And
Unable to deposit.
Unable to deposit, and as such there is no interim order. As I
Lord, so it will be clear.
Because at this stage, the learned counsel for the petitioner has submitted that by virtue of interim order dated
10/8/2022.
10/8/2022, the petitioner has not been able, petitioner was directed to deposit an amount of ₹50,000.
50,000.
And a conditional stay order was passed by this court. But the petitioner was unable to deposit that amount, and therefore the stay order which has been passed in favor of the petitioner is not operating.
Is not.
However, in order to give one opportunity to the petitioner to file an affidavit in connection with compliance of the various orders passed by this court in the matter of payment to opposite party number 2, the affidavit is required to be.
So at least 2 weeks time may be granted.
No.
So that he is
No,
of
no.
Bihar, my lord sir. That's why, my lord sir.
Lordship, he submitted before the court that they will deposit rupees 50,000.
Let it come
On
on
that
next-
basis,
on next
Lordship,
Friday
stay
it will
was.
come. On next
Lordship.
Friday it will come. You just-
Lordship, it will be made clear that interim protection is not there. So that,
It
Lordship,
will come next Friday. I'll pass an appropriate order vacating the whatever. We'll say that it is not there and we'll communicate also.
Yes.
Final.
next Friday. Lordship.
Item 33, criminal
Let him
division.
have an opportunity to give some payment.
Lordship, 12 times mediation was done in the court below. And 7 dates were before the mediation, again before the Sahabganj, Lordship.
What is he doing?
He has furniture shop, Lordship, and he has married again, Lordship, with another lady.
Item 33, criminal division 540 of 2022.
Yes.
My lord, this is a matter of 138 of NIA. On the earlier date, my lord, it was sent to Lok Adalat for settlement, but unfortunately it failed.
Your father?
Petitioner,
Complainant or accused?
accused.
What is the date of check?
25/8/2009.
25/8.
My lord,
Amount?
amount 60,000. My lord,
Vouched for what reason?
my lord, it was a friendly loan.
Stop payment or funds insufficient.
Fund insufficient.
So you issued the check by way of loan?
No, my lord, I took the loan. I took a friendly loan from the complainant.
Because a refund to that loan?
Yeah. No, my lord. I have taken that loan for renovation in my clinic, and I was unable to pay it back.
So?
And my lord, I'm just praying that this matter be sent to Jharkhand, because in the Lok Adalat, my client, the petitioner, was not ready to settle the matter because of some conflict in the conditions. But I took the instruction today itself, my lord, and he is ready for settlement. And I've already deposited a demand draft of 60,000 before the Registrar General.
By which order?
Order dated 28 April 2023.
Just tell us what is the settlement amount, we'll settle it here and now. What is the, why should we settle it?
As a last chance, my lord, it may be sent for Jhalsa.
Not required, no? You just tell me what is the amount, we'll ask, immediately ask the opposite party. You can ask them. You have OP number 2, the opposite. You want the 60,000, you want settlement.
लॉर्डशिप 60,000 लॉर्डशिप झालसा में हुआ था ऑर्डर लॉर्डशिप उन्होंने बोल रहे हैं कि 6,000 रुपए ही बस हमको देना है.
No, he is ready to give 60,000. Are you?
Yes, my lord, she is telling the grounds. I have taken the ground that my lord.
No. Are you ready to settle for 60,000?
Yes, my lord.
यहाँ पे लॉर्डशिप.
You just tell us he is ready to settle for 60,000. Are you ready to accept?
लॉर्डशिप ready.
My lord, but last instance के लिए एक बार झालसा, my lord.
किस लिए जाए? कोई काम नहीं जाए.
एक बार my lord मेरा client का instructions था कि एक बार settle करने का एक last try.
Settle तो यही कर दिए ना. They say that they are ready to accept. What further settlement do you want? There is no dispute. You are ready to pay. They are ready to settle. Matter is. Story over. You file joint compromise petition for 60,000. The matter will end.
My lord, एक last.
नहीं, give me one reason to send it.
कुछ my lord कुछ conditions है my lord कि मेरा ये claim है कि हम medical supply के लिए इनसे मेरा medical supply का काम चल रहा है.
Disputing
Yes, my lord.
So you are not saying that you are ready to settle at 60,000, which is a check amount.
No, my lord, I have stated in the order of on the same date, I think, my lord, 28 April order, my lord, that I am ready to settle for 60,000.
That's enough. They are ready to accept, you are ready to settle. Matter ends. You file your uncompromised petition, you file. It's a local matter. You see, technically, I must tell you that when this settlement is done, at times some interest is also fixed. But they are ready to accept because they also know it is so difficult to realize the compensation amount.
My lord, I am just requesting because I got the instructions from my senior.
Request rejected. Yes, you are ready to accept 60,000. Yes. Should I record? Yes, madam, I am asking you, should I record that you are ready to accept 60,000? What was the compensation amount?
1,20,000. 1 lakh to the complainant and 20,000 to the state.
Who is your senior?
Mr. Lokesh.
Call him, please. Maybe that you are not able to communicate. Call him. Just keep 5 minutes.
Pass over this from Delhi list item 2, criminal revision 42 of 2023.
Mr. Lokesh, are you ready to settle for 60,000?
Yes, sir.
They are ready to accept. Fine. The learned counsel for the parties are present. The learned counsel for the petitioner submits that an amount of 60,000 has already been deposited before the learned registrar general, which is a check amount. And upon this, and he is ready to settle the matter at 60,000. The learned counsel for the opposite party number 2 has also submitted that the opposite party number 2 is ready to accept the check amount as full and final settlement. And upon receipt of that amount, the review order, so far as it relates to the amount payable to the opposite party number 2, these are that has gone to the state, right? Out of the entire compensation amount, out of the entire amount, 20,000 has been directed to be paid to the state. She has also submitted that. That should be sufficient. Also for the local matter. At this, counsel for the parties have submitted that the matter be posted next week so that, if so advised, a joint compromise petition.
2 weeks, please.
Post this case on 1st of March.
Yes.
24. First March will be 2 weeks.
No, 7th March.
7th March. 7th of March 2024. Under the heading for final disposal. Awaiting. That should be sufficient. The conviction will be set aside. But additionally 20,000 will have.
Passover case item to criminal division 42.
Lordship, I was praying for one short indulgence. Due to eye infection, I am not able to read the file properly. Only for next Wednesday, Tuesday, Wednesday.
You are there?
Lordship, yes, in serial number 3.
You are there?
Lordship, in my case, Lordship, I contacted the counsel who conducted the trial for the trial court. Lordship, he informed me that कि 6 महीना पहले इसका एक्सीडेंट हुआ था, तब से मतलब बहुत सीरियसली हुआ था. तो उसके बाद से एक नंबर है वो भी नहीं फोन में कांटेक्ट में whether he is live or
We will not assume that a person is dead.
लॉर्डशिप तो कोई इन्फॉर्मेशन ही नहीं है उसके बाद से. एक नंबर था वो भी फोन लगना अब नहीं बंद हो गया आफ्टर दैट इंसिडेंट.
जल्दी बेल मिला है, बेल बॉन्ड कैंसिल कर देते हैं, अपने सारा इंफॉर्मेशन आ जाए. All the information we will gather once the bail bond is cancelled.
इसमें तो हाफ ऑफ द ज्यादा सेंटेंस कंप्लीट भी कर लिया.
मेरिट में बहस कर लिए, वकालतनामा मिला है, मेरिट में बहस कर लिए. You don't have any intimation. You have the intimation that he suffered an accident, but you don't have the intimation as to what happened to him.
डायरेक्ट ये नहीं था कांटेक्ट. वो लॉयर से हम पूछे तो वो बताएं जो वो हम उसको
We'll cancel the bail bond the moment you say that you have no instructions. You have वकालतनामा, you are illegal.
एक बार को नोटिस कर देते हैं.
नहीं करेंगे notice. It is a very recent case. It is not an old case. It's a very recent case.
लॉर्डशिप,
There is no question of issuing any notice.
क्लाइंट हम लोग का
ये सारा कुछ करके जज बने, इसलिए मत हमको ये सब बताइए.
तो हुजूर को तो मालूम होगा फाइनल
लाइन देने का क्या क्या बहाना हो सकता है. इस पर एक रिसर्च टीम है झारखंड हाईकोर्ट. They focus more on how to take adjournment. Right?
लॉर्डशिप हम लोग को दिक्कत नहीं है आर्गुमेंट करने का. लास्ट कांटेक्ट नहीं है. एक
Do not have any contact.
है हुजूर, हम लोग को फीस भी पूरा नहीं पाए.
फीस नहीं मिला है तो आप उनको सू करिए.
तो एक बार हो जाता है हुजूर इंफॉर्मेशन की तो हम लोग को कांटेक्ट कर लेता तो हम रेडी होके करेंगे. इसीलिए फॉर हम लोग का बेनिफिट के
ऑनलाइन सारी
कोई दिक्कत नहीं.
कॉन्ट्रैक्ट दे दिए ना.
सही बात है.
must have received the contract by now.
Be fairly, I submit it for a person कि ये.
You see, notice I will not issue. इसके पहले कि वो मर जाए या उसको कुछ हो जाए, क्योंकि आप बोल रहे हैं बहुत सीरियस है.
आप उनसे पूछे.
All the more reason that I should
वो
hear it.
नंबर भी नहीं दिया.
During the lifetime of the accused, the case should be decided. Isn't it?
Yes.
You should know during his lifetime as to what he has done. Acquittal होना है तो भी हो जाना चाहिए.
एक एडजमेंट दे दीजिए, फिर से एक बार ट्राई करते हैं.
आपका पॉइंट क्या है? मेन पॉइंट बताइए. फाइल भी गुम हो गया क्या?
नहीं, फाइल गुम नहीं.
थैंक गॉड, फाइल गुम नहीं.
फाइल गुम नहीं.
फिर क्या मैटर करते हैं? What is your main point? Who's for the state?
शैलेंद्र कुमार तिवारी.
He's also absent.
He is not absent, Your Lordship. He is another party.
What is your main point?
Lordship, in my name has been transpired in the present case only on the basis of confession. Though nothing has been recovered from the possession of this petitioner. Only कि ये मंगाता था और क्या ATM कार्ड बनाने वाला मशीन ऑनलाइन eBay बिल वगैरह से मंगाया था ATM कार्ड बनाने का. Though nothing has been recovered from the house or from the possession of this petitioner when he was arrested or interrogated by the police.
ATM cards have been recovered.
Not from my possession.
That's right.
From other persons. And they have disclosed the name of this petitioner, and thereafter he has been arrested and implicated in the present case.
Lordship, very interestingly, all those ATMs which were recovered, they were never put before the exhibited before the lower court. And neither the names which were revealed on the ATM cards that was put before the court. So only on the basis that I was standing outside the ATM and I was having 5 ATMs. All those 5 ATMs are with me now. They are all of the family members, and it has been falsely implicated that we have been arrested from the ATM place of ATM card. Whether we were actually
arrested from the house. Later on, it was shown that no, we have been arrested from the ATM around the area. And there is discrepancy in all the prosecution, the way it has been conducted. Neither the ATM, nothing has been brought exhibited, only on the basis that I was there and I had a deposit slip of 20,000 and I have been arraigned, both have been arraigned. And there is not a single case either by the bank or by a private party that there has been any fraud or any cyber crime which has been committed by us.
No victim has come forward
I
to
must
claim.
say that even if your eyes are not in order,
No,
remember a lot.
I have
recently
actually prepared the quiz, but
mail
yesterday night I
SPM.
started having pain in my eyes, so I could not. I remember the case, everything.
So according to you, it's a case of clear acquittal.
Lots.
Yes.
So you are not ready to argue. You don't want acquittal now.
एक एडजर्नमेंट केवल बस कांटेक्ट के लिए दे दीजिए लॉर्ड्स। इट्स अ गुड केस आई नो बट
कल किसने देखा? हो सकता है कल हम ज्यादा ब्रीफ पढ़ लें।
Next week, Your Lordship, I will be also ready.
तो और अच्छा ऑर्डर होगा लॉर्ड्स।
और अच्छा ऑर्डर।
Yeah, the very ingredient of 406 is absent.
Opportunity never comes twice. Right? Ever in life. Okay, when do you want?
Next week, I'm ready.
नेक्स्ट वीक
And where is the counsel for the state? Are you there?
Yes.
Yes, please come. There are certain questions to you. They say it's a case of no evidence against them.
No, there is evidence, Lordship.
Which is that clinching evidence according to you? Is it a crime to have number of ATMs? Is it a crime to have number of ATMs?
Yes.
Yes. Show me some law. Did you send the ATMs for examination by any authority, whether they were genuinely issued by the bank? Has any bank officer?
एक केस के लिए पास ओवर किया जाएगा। एक
पास
केस।
ओवर करेंगे तो उनको तो टाइम चाहिए आज एक्टिकल लेके। लेकिन these are the questions which will come.
But if the ATM of others are kept for the purpose of crime, Lord.
Preparation for committing a cyber crime is an offence. Let us assume everything in it. Like dacoity, preparation is an offence. Preparation for cyber crime, is it an offence?
But the other circumstances and conduct of the appellant.
What conduct? On the basis of conduct, can you convict a person?
The
The
appellant.
ATMs which have been recovered were not even exhibited before the hearing. The ATMs which have been recovered was never sent for any forensic examination. The bank officer has not turned up. No victim has turned up. No complaint. You just went there, saw a person with number of ATMs, arrested them, convicted. This is the entire story. And this is not a solitary case, so I want to decide this case properly. Because there are so many such cases in Jharkhand. Merely on the basis of recovery of certain ATM cards, you are convicting them. And I know that you are a very good counsel. So you prepare yourself well. I'll ask you these questions to you. I'll give you sufficient time, prepare your notes and the evidences. Right. You are special counsel for cybercrime?
Yes.
Consult your IO and everybody you want to. You can consult experts also. Has any such judgment been passed by this court so far on this point?
देख लेते हम वेरीफाई कर लेते हैं।
यहाँ का भी वेरीफाई कर लीजिए, दूसरे कोर्ट्स का भी वेरीफाई कर लीजिए।
इसमें कुछ तो प्रोसिक्यूशन में एट द टाइम ऑफ आईए जो इनका एप्लीकेशन बेल का हो रहा था उस समय हम लोग थॉरली हियरिंग किया गया था। देयर आर सम लेचेज इन द पार्ट ऑफ द प्रोसिक्यूशन आई एम एडमिटिंग इन दिस
You
केस।
see, we will not see it on this case only, because whatever we will pronounce will have a bearing so far as the point of law is preparation to commit a cybercrime by itself is not an offense, crime facie. In only few cases, preparation is a crime, isn't it? Or there could be a licensed item, like if you are in possession of a gun without a license, that's a crime.
That is offense.
ATM is not a licensed item.
I understand.
Criminal revision number 256 of 2022 with analogous case number डाल दीजिएगा.
42 of 2022.
The learned counsel for the parties are present. Should I record that some arguments have been advanced?
I do.
Not really. At the request of the counsel for the petitioner, the matter is adjourned and is directed to be posted for final disposal on next Friday.
नहीं एक week और कर दिया.
Friday छोड़ के कोई दिन
On 7th of March. 7th
तो Friday को ही रख दीजिए. Friday को.
Thursday.
7th को एक्चुअली हम 7th से 11th 6 से 11th हमको नहीं रहना है.
5th और 6th
6 से 11 के बीच में नहीं रहना.
5th को रखते हैं.
5th को रखा जाए.
Are you there on next? You can't post it on Wednesday. On 24th of March.
No.
2024. Just make clear that no further adjournment will be given. नहीं आइएगा तो MI से support करके decide.
इनका अच्छा कैसे तो ले जाएगा.
You do not find this. It is just a fantasy observation. Subject to the records, we see what are. You are in divisional jurisdiction. You have to show some perversity. It's special purpose.
Passover case item 5, criminal revision 63 of 2022.
In this case, Passover short times because we consider Mr. Ajay Kumar Trivedi in court number 3.
This was already passed.
अभी ongoing कर रहे हैं court number 3 में.
Exactly.
215 में रख देंगे.
Your Lordship, I was directed on the last day to file a reply to the interlocutory application, Your Lordship, till yesterday, but due to some inventory.
You have objection?
No, Your Lordship, I've
File it. We condone the delay.
we've not filed it, Your Lordship, but this is ready, Your Lordship, it may be taken on record
It
today.
will be taken on record. We'll decide it. The second half, he says second half. Okay, second half.
Yes.
You file your IA.
Okay, I just received it.
Item 27, criminal revision 364 of 2022.
The Lordship has rightly pointed out that provisional bail was granted on 18/8/2022 for a period of 2 months. Thereafter, for a period of 2 months, not originally. Thereafter, on 16/12/2022, even in absence of the earlier order is 18/8/2022. It was for a period of let's just see 4 months. Therefore, not on before its expiry, the period of expiry of the period note, that is 18/12. On 16/12, the matter was placed before the Supreme Court as per the earlier order, and on that day, the Honorable Court, in absence of any interlocutory application for extension, since it was within time, therefore it was extended to 31st March 2023. Then what again, it was as per the order.
Sorry, 31/3/23.
Yes, 31/3/23. Then it was placed on 31/3/2023, as then it was again extended till next date of hearing. So, as I have already instructed my client, he is ready to he is not feeling shy not to surrender. But your lordship may kindly appreciate for a moment, when he was on bail till today, he is on bail. The learned court below may not, my apprehension, may not accept, but it is not necessary. If your
No,
lordship,
he will accept, we will direct them.
no, your lordship may, otherwise also, this is a case, your lordship, another aspect. This is a case where the matter was remitted back by your lordship, not by setting aside the matter. Appellate court was directed to rehear. And the appellate court, after rehearing,
We will not.
within the period of
We will not hear the case on merits unless you surrender.
it was the period has been reduced to 6 months, and he remained in custody in 4 months already. About 4 months out of 6 months.
One day also you have to surrender. We cannot.
No, I am not feeling shy, my lord. He is not feeling shy to surrender. But if he is on bail, that is the problem. I have already directed,
He has been
instructed.
granted only provisional bail.
That your lordship understands, but for the court below, the bail bonds are furnished pursuant to the order of the Supreme Court, and he is still continuing on bail as per the order existing. Till date he is on bail. But I will follow, I will bound by your lordship. May I pray not one thing more? I is ready to surrender. Only your lordship may indicate it. My submission may be recorded in the shape of my submission, and the learned court below may accept his surrender, and your lordship may keep it not after 1 week or 10 days. In the meantime, I will file the surrender certificate with a prayer for bail.
No, I will hear it finally.
Then he will complete the sentence at all. You must just see this.
You just file your surrender certificate on next Thursday. I will hear it on next week. I have no issue on that.
Next Thursday.
You just tell us when you want to file your surrender certificate. You can't have
Within
it.
after 10 days. Your lordship granting 8 days, I am saying 10 days.
How much of custody have you served?
Yes, your lordship just. He surrendered on 2nd January 2013.
What is the punishment?
Punishment in I have not, that is, sorry, 304A and 279 IPC. The trial court, the order of sentence has been modified by the learned appellate court, which is under challenge. That is, your lordship may can see it is for 6 months with fine of ₹1,000.
The learned counsel for the
And he remained in custody
is present.
before provisional bail, not 3 months, 10 days.
The learned counsel for the petitioner has the IPC has submitted that a provisional bail was granted to the petitioner by the order dated
18/8/2020.
2022. For a period of 4 months. And thereafter, before expiry of the period of provisional bail, by the order dated 16/12/2022, the provisional bail was extended till 31/3/2023. Thereafter, on 31/3/2023 also, the provisional bail was extended till the next date.
Opposite party number 2 was directed to file counter. On that day, it was adjourned.
That's it. LCR Act. Copy of the lower court records has already been received. The learned counsel has submitted that the petitioner has already remained in custody for the
3 months, 10 days.
period of 3 months, 10 days. considering the fact that the learned council has submitted that the period of provision.
And thereafter, from 4/7/2022,
That's it. You have said 3 months. 10
for
days.
more than 4 months.
You
Because
give the exact time.
exact date, 3 months, 10 days earlier in the during trial, and thereafter, 4/7/2022, 18/8/2021, and 1 month, 10 days. So it comes to 4 months and 4.5 months.
4.5 months. Around 4.5.
Yes.
The lower court records has already been received. In order to clear the matter, the petitioner is directed to surrender before the learned court as he was released only on provisional bail and file a surrender certificate before this court. Right?
After 10 days,
First of March.
first Saturday, Friday, most probably.
First is Friday. You file it by Friday.
4th, your lordship may fix it, not 4th.
You file it by 1st of March.
Yes.
By 1st of March 2024. Preemptive. If the surrender certificate is filed on 1st of March 2024, let this matter be posted for final hearing on 4th of March 2024 to be taken up as first case. You have for OP number 2?
No, my lord, I may appear on behalf of the state.
State is present, OP number 2 is absent. Counsel for the opposite party number 2 is absent. We will decide it on that.
Yes.
You prepare your short synopsis and let us see what is in it.
Nothing to be pressed not only on the point of sentence.
We'll do it just 2 days, but you have to surrender.
And sir, I have already instructed him to surrender. The difficulty as expressed by the local lawyer that he is on bail, therefore he could not surrender. Otherwise, I would have it in my hand.
Let this order be immediately communicated
Yes.
to the learned court.
That is the problem. Otherwise, I would have had in my hand not the surrender certificate. I have already instructed him to surrender.
Item 28, criminal revision 298 of
4 तारीख को
2022.
याद दिला दीजिएगा.
हम खुद
2:15 बजे नहीं मेंशन करिएगा. 4 बजे हमने सुनेंगे मेंशन.
हम 10:30 बजे अगर होगा तो 10:30 बजे कर देंगे.
सवाल. Yes, petitioner.
This revision has been filed against the order of acquittal. The complainant has preferred this revision.
Timeline was not followed.
It was the finding of the learned trial court, Your Lordship.
Tell us how is it?
Yes, sir. Page number 33 is the finding, Your Lordship,
33.
of the impugned of petition. Page number 17 is the.
Is this the only ground for setting aside?
Yes, yes.
Is
Premature.
that the only ground? Who is for OP number 2?
Notice was not serving the first time.
Let us see.
Yes, sir.
Does primary facie satisfy?
Yes, sir.
I think I was not satisfied on the last time.
Yes, Your Lordship.
Yes.
On 15/5/2017, it is the date of issuing of impugned check, Your Lordship. And 18/5/2017 is the check was bounced by the bank. And as per the 138 subsection B, Your Lordship, 30 days time was granted to send the legal notice. Within the time it was sent by the petitioner, Your Lordship. And after 35/2017, the complaint was filed on 36/2017. That is after the lapse of 30 days, Your Lordship.
31 days.
30 days.
So the 31st day.
31st day.
On 31st date was. So the
You should have waited for 15 days now.
it is 15 days, Your Lordship. On 35/2017, the legal notice was sent.
Yes.
And after
Date of service.
date of service,
It has to be counted from the date of service.
and the date of service was not brought on the record, but Exhibit 3 is the legal notice which was served by the complainant, that is present petitioner. Which are not looked by the London trial court. Yes, sir.
What's that?
Service notice which was served to the opposite party, that is respondent.
No, I'm not able to get it. What is the date of service of notice, your legal notice? Or we have to, there has to be a deemed service.
Deemed service at 27 days, and as per that also, this complaint is not premature. That after the 31 days, that complaint has been filed.
After the service of notice, you have to wait for 15 days.
Yes, sir.
And
After
then
the
only
service,
the cause of action to file the case arises.
yes, sir.
So after the expiry of 30 days, that is deemed service of notice, 15 days was yet to expire, and you filed the case on the 31st. So was it not premature?
But when the service report is not there, the presumption is that it is a deemed service.
Deemed service when?
When the notice has been served.
Then what is the date of service? 30 days from the date of issuance.
30 days. And it is
30
on
plus 15.
It is on the 31st day.
So 30 plus 15 and then you file a case. Isn't it? Let us see the trial court order.
Yes, sir.
You have challenged the trial court order
Yes, sir.
directly before this court.
Yes, sir. And at the same point, I have submitted that it had to be filed under 378 subsection 4 for the leave to be granted before filing this. And the office had pointed out the defected for
This is an appealable order. Before sessions court.
not be directly before the session court, but it had to be take a leave from the High Court after that.
No. The order passed by the trial court is subject to appeal.
But this is the complainant arises out of the
You
complaint.
can't file an appeal before the appellate court.
No, Your Honor. Directly we cannot
Show
handle.
me something.
I had not brought that.
On the last date also you did not.
Yes, sir.
You consult somebody.
It is, I have
There
the
are so many cases which we are getting, isn't it? The complainant is filing appeal before the appellate court.
I have the citation of the judgment, but I have not brought that due to some difficulties.
What difficulty?
I am not able to procure it from the library at that time.
You don't have form.
I have one. That is not reported, Your Lordship.
Unreported.
Not reported, but we cannot get it.
You can't get it.
It is 2021-19 of volume 2, Mallikarjun Kodagli versus the state of Karnataka.
It is not a reported case.
Reported case, Your Lordship.
Then
I will bring it on.
Ladies, sir, I will assist on the next date. I will try to procure.
tomorrow. उनको citation दीजिए, उनको किताब दीजिए पढ़ने के लिए. You sit there at the corner and read the whole text of the judgment. Right? You don't have time at home. You don't have the book. We are giving you the book. You read it. आप कोर्ट से बाहर नहीं जाएंगे. यहाँ पर बैठे, वहाँ बैठे, पढ़ना है full text. पढ़ लीजिए. दीजिए citation दीजिए, हम मंगाते हैं आपके लिए.
I will read it. I have.
अभी तुरंत मंगा. Also for the petition is not ready with the bill post-mortem. You just get it. Right? This is an appealable order.
This is an
Complainant can
appeal.
file an appeal.
This is an appeal.
Item 29, WPC 4534 of 2023.
in this matter, petitioner prays for passing of annexure 6 series and 7 series. And in this matter, my lord, there are 3 periods. First period for passing of annexure 6 and 7 series. After that, my lord, direction will be given to refund the entire recovered amount from the monthly pension of the petitioner.
6 series. Where is the order?
Page 31. Karjalaya.
File your counter.
No, that's why I was praying, my lord, that let it be after 4 weeks, my lord, I will file the contract. Matter is coming for the first time. The state authorities, said the Union of India, my lord, informed us through annexure 6, my lord, page 31.
Page?
Page 31. They informed us, my lord, the centralized pension cell, my lord, that due to our some mistake,
You annex that undertaking.
my lord,
That if there is any excess payment.
that is there, my
that
lord.
will be
Now it
recovered.
is squarely covered by the orders of this honorable court, my lord, and the division bench of this honorable court. That the bank has got a right to recover if by
there is any
our
excess
mistake,
amount has
if due to our mistake some payment is made. Only the principle of natural justice has to be followed. Notice has to be given. Yes, notice is there after, my lord, annexure page 33, my lord, annexure 7.
Which all judgments are you saying?
My lord, that I will come with all those, my lord.
The learned counsel for the parties are present. WPC number 4534 of 2023 with IA number 9045 of 2023. Counsel for the petitioner has submitted that the matter relates to recovery made by the respondent bank.
No, my lord, respondent, state authority,
the Union of India,
Union of India, as well as bank, my lord.
By the respondents.
Yes, ma'am.
He has filed an interlocutory application for stay of recovery which has been directed through installments. Counsel for the respondents is directed to seek instruction and file a counter affidavit in the present case. By where is Union of India? They should also file counter.
Because they are necessary party, my lord, they have deducted it, my lord.
By
And we have also
7th you will file it?
7th of
March.
let it be one more week, my lord.
Stay
Because
करते थे recovery?
एक हफ्ता
नहीं?
पटना से है ना.
So what? Patna
अच्छा
is
ठीक 7th
by 7th of March.
आजकल आना पड़ता है मुझे.
2024. Let the counter affidavit be also filed on behalf of the
Union of India.
respondent number
1 and
1 and 2. Who is appearing for Union of India? Since nobody is appearing on behalf of Union of India, let a copy of this order be communicated to the Office of Learned Assistant Solicitor General of India. Are you there?
I'll inform my senior about this.
You are there with Union of India?
Yes, ma'am. I'm AC2 SGI. Priyanshu Shekhar.
Priyanshu?
Shekhar.
ऐसे लिखे Mr. Priyanshu Shekhar, advocate.
Yes, ma'am.
Appears on behalf of respondent number 1 and 2. You have to file your counter affidavit by 7th March. Close this case on rejoinder if any by 14th March, post on 18th of March 2024 under the heading for final disposal. Any recovery made will be subject to the final result of this case. Accordingly, IA number 9045 of 23 is hereby disposed of.
Much.
Item 34, Criminal Division 624 of 2022.
In this, we have filed a supplementary affidavit proposing settlement. We are ready for settling the matter, Your Ladyship. So it may either be referred to Jhalsa or local.
You deposit the amount in the High Court, then only it will be returned.
Lordship, they may make an offer to that effect, or at least tell me
You
whether
deposit it. If you are ready to settle, you deposit it.
we are ready to pay Your Lordship 1 crore 50 lakhs as per our submissions in the supplementary
Have you
affidavit.
filed your surrender certificate?
Surrender
Surrender certificate.
I don't know. There is an interim order that is there, Your Ladyship, in this order, that was provided to us for no coercive steps on 29/9/2022, Your Ladyship.
Because that ALIA is still pending. Is there any pending ALIA?
Yes, yes.
ALIA number 8358.
Yes.
That is still pending. Exemption from surrender, no final order has been passed. There is only an order of no coercive step.
Yes, Your
So you surrender.
Your Ladyship, she is a kidney patient. She has recently donated her kidney to her husband, Your Ladyship. And therefore, in the meantime, in December, the operation took place, Your Ladyship.
You want to settle the matter?
Yes, Your Ladyship, we are ready for settling the matter.
What is the check amount?
Your Ladyship, the check amount was 8 crore 18 lakhs, but Your Ladyship, they have attached most of our properties and even auctioned most of them. Now there is also an appeal. Yes, Your
They have
Ladyship.
recovered
Yes,
some
they
amount.
have recovered
What is the
some
amount they
amounts.
have recovered? Don't make statements which are beyond record.
Yes, Your
right?
Ladyship, we have recovered. They have recovered close to 2.
You must be knowing the exact figure.
Yes, Your Ladyship.
You cannot have a tentative figure of recovery, isn't it?
Your Ladyship, from 4 of my properties, they have recovered amounts.
Amount, please.
Yes, from the first property it is 16 lakhs, from second property
Give
it
me
is
the total.
yes, sir.
It was auctioned arising out of this proceeding, or it was auctioned
in a
some other
DRT.
proceeding?
In DRT, Your Ladyship. They had gone to the Debt Recovery Tribunal, and there
Who had filed the case?
the complainants had filed.
Who is the
bank.
complainant?
The bank had filed the case.
The bank is the complainant.
Yes, Your Ladyship. It was a complaint case that had arisen, Your Ladyship, under 138, and there was conviction, and also
Auction is not under challenge.
Yes, Your Ladyship, we have filed recently against the appellate order that was passed. We have again filed an appeal from that appellate order, which is pending, and we have
That is a
also.
separate thing. You talk about that check now.
Your Ladyship.
You want to compromise, you have to compromise
Yes.
everything, even that whatever, if you want that particular amount which have been recovered through recovery proceedings in DRT,
Yes.
then you have to forego all your claims in connection with that.
Very well, Your Ladyship. They may make an offer to us
No.
that.
You make an offer.
Yes, we have made an offer and we have bought it on record
What
as
is that
well.
offer that you will not challenge you will withdraw the challenge to the recovery
Your
proceedings?
Ladyship, if they agree to our offer,
No,
we
you
will.
just, first you have to make an offer, madam.
Very well, Your Ladyship. I'll bring it on record, and I will state that if so and so happens, we will even recover the. We will withdraw all the cases that are pending against the appeal that we have filed, being appeal number 74 of 2024 as well. I'll bring everything on record, Your Ladyship.
LCR has come.
No, Your Ladyship, LCR does not come.
So as per your instruction, how much you are ready to deposit?
Your Ladyship, in July 2023, the application that I had filed, supplementary affidavit, at that time I had made an offer of 1 crore 57 lakhs.
So you deposit 1 crore 57 lakhs before the registrar date. If that is the offer, you deposit. We'll see.
We are ready to deposit that, Your Ladyship. But Lordship, at least 20 weeks may be granted to deposit because I'll have to sell out 2 properties to deposit that
You don't
amount.
have any, no, everything is
No,
under
Your Lordship,
attachment.
one property is remaining.
Give me the details of that property.
Yes, Your Lordship, I'll bring it
Right now. You go out,
I'll
take
ask.
it in WhatsApp and give the details of the property which you want to sell.
Very well.
Because there is a likelihood that all the properties must be under attachment.
Very well, Your Lordship. I will take instructions from them.
Document in you are representing whom?
Your Lordship, bank.
What is your instruction? This was over and above. This was over and above the dues which were there in TRT, or it is inclusive?
Your Lordship, the earlier OTS was rejected and he has given fresh proposal. And now they are having 6.55 crores on their balance in their account.
After adjusting this statement, where you have filed a contract in it?
Take instruction, Your Lordship.
Who is your senior? You are
Mr.
so
P.
casual about this. Call Mr. Pranav. You are so casual about this. It's such a huge amount. Call Mr. Pranav. He should also be here at 2:15. Right? Because maybe that there could be a gap between what I say and what you say.
Your Ladyship, it may not be fixed at 2:15 because there's already a matter fixed in court number 4.
Are you going to argue? I know you only seek time. Your senior has only instructed you to seek time.
I have to assist.
You come at 2:15. I will sit at 2:15 sharp. You should ask your senior to give you briefs for arguments.
Item 35.
Isn't it?
Yes. He does, Your Ladyship.
I'll ask him also.
He does, Your Ladyship.
Item 35, Criminal Revision 651 of 2022.
138 NIA committee. Kindly see order dated 12/12/2022. It's a copy.
In this case, what happened? Where is the compromise?
Yes.
Where is it?
Annexure IA number 7644.
It is a joint compromise.
नहीं. Joint ये मनी रिसिप्ट है. उसके बाद उसमें एक स्पेशली लिखा हुआ है कि हम इसके आगे अपना केस को नहीं करना चाहते मनी रिसिप्ट में. उसके बाद नोटिस भी हुआ है जिसमें कि पैरा 5 में एनेक्शन नंबर 1 पेज नंबर 9 मिलो IA नंबर 7644. Yes.
What is the date of compromise?
9/6/22.
Yes, encashed your checks.
नहीं आपको 1,50,000 कैश एंड 40,000 का चेक.
So you have given the check also, no? Has he encashed the check? You are the accused. You paid the money through compromise.
Yes.
Partly was paid in cash and partly was paid in check.
Check.
Has he encashed the check? This compromise has not been.
Several time on order dated 9/9/22, 2010/22, 11/11/22. Several time notice has been issued, but opposite party not appearing.
Maybe not appearing. We cannot enforce any compromise on them.
Not already in the
Anything can be compromised only by way of joint compromise petition to be filed in the court. If you enter into some kind of compromise outside the court proceedings, then also you have to file a joint compromise petition. Where is that? So you argue the case in their absence. ऐसे compromise होता है, आप लोग क्या सोचते हैं? And this has happened. You just see the order of the sessions judge is 17th January 2020. You enter into a compromise on 19/6/2020.
Yes.
2022.
Two.
Right?
Yes.
Privately. It is a joint compromise petition. And how can such a money receipt which you have annexed along with the alley can be taken into consideration?
फिर उसके बाद एक सेकेंड ऑर्डर भी है मेरा
ऑर्डर से नहीं होगा, केस बेंच करेगी।
नहीं तो उसमें भी लोक अदालत में डीएलएसए के थ्रू उनको सेक्रेटरी के तरफ भी कोशिश किया कि यहाँ अपीयर हो,
He
लेकिन
is not coming. He is not interested in compromise. He cannot force anybody to participate in any mediation proceeding or in a compromise. Mediation, compromise is an absolutely voluntary act. The direction for imprisonment is totally different from the check amount. Even if you give the entire check amount, that will not compound your imprisonment unless he comes and agrees to.
फर्दर टू बी टाइम के एक बार कोशिश करेंगे उनको बुला
कुछ नहीं कोशिश करना है, आप प्लीज बहस करिए। सब टाइम लेने का ये सब कहानी मत हमको सुनाइए।
मेरा टाइम हम कहा एलसीआर भी नहीं आया है मेरा
वो बात
एलसीआर भी नहीं आया है क्योंकि ऑलरेडी वो पैसा लेके फिर आना नहीं चाह रहे हैं।
गलती की है।
हाँ।
प्राइवेटली कोई कॉम्प्रोमाइज करता है। And he has not even encashed your check, so you cannot actually say whether he has this document is genuine or not genuine.
हम एक बार वो भी 40,000 को चेक दिया उसको भी हम पता कर लेते हैं कि कैश हुआ है।
Unless a joint compromise petition is filed, we cannot do anything. Criminal Division number 651 of 2022. Counsel for the petitioner is present. Nobody appears on behalf of the respondents. The counsel for the petitioner submits that after the interim order passed by the learned court dismissing the appeal on 7th January 2020, the certain amount was paid to the opposite party number 2 by way of full and final settlement, and for which a money receipt dated 9/6/2022 was drawn, which is annexed along with the interlocutory application. The learned counsel submits that in spite of notices, the opposite party number 2 is not appearing, and repeated attempts were made for mediation to Jhalsa or Dalsa?
Jhalsa.
To Jhalsa, but he did not appear at Jhalsa also.
Yes, what is the order?
The learned counsel submits that admittedly no joint compromise petition has been filed in the present case. He submits that the petitioner has been exempted from surrendering, considering the aforesaid aspect of the matter. He also submits, in view of the aforesaid facts and circumstances, particularly that no joint compromise petition has been filed in the present case, and the opposite party number 2 is not taking any interest in the present case, even in absence of opposite party number 2, the case has to be considered on merits. Call for the LCR call for the records from the court concerned. pose this case on March 2022.
2024.
2024. Let this order be communicated to us.
Item 36, criminal revision 661 of 2022.
My lordship, it's a case under section 138 NI Act. I was complainant in the court below. Case was allowed in my favor, and while in appeal, the judgment of the trial court was set aside as being premature. I will take your lordship to the cognizance order. Since in the complaint petition, only it was mentioned that the legal notice was sent on such and such date and after receipt of such and such. A specific date was not mentioned in the complaint page. Therefore, the trial court's order is there.
Which is the trial court judgment?
I will come to the judgment. Prior to that, I am coming to the order of
The records
cognizance
would
order.
be required.
I have covered everything.
The records would be required.
Firstly, also under 401 of CRPC clause subsection 3, that this court has no power to convert the order of acquittal to the conviction. That is a specific bar in the section, Your Lordship. And you will do section 401.
So against this order,
They have to prefer an acquittal appeal, Your Lordship.
No.
And I have to rely upon the Joseph Stephen judgment, Your Lordship. There are two possibilities, Your Lordship. Para 11 and para 12, Your Lordship.
this is arising out of NI.
No.
The same thing, Your Lordship, against the acquittal, they have preferred a revision application. In that case, the Honorable Apex Court has held that there are two possibilities. Either this Honorable Court has to set aside the matter and remand back to the appellate court, Your Lordship. Second thing is that they have to convert the same into acquittal appeal.
In revision, can it be set aside and directed back to
Yes,
the appellate
that
court?
is there.
So at least to that extent,
That is, yes, that is
that we will not convert it into
order of conviction.
order of conviction.
Yes,
But at least to see the legality and propriety
that
of
can
the
be
order.
that can be done. Yes, sir.
That can be done?
Yes.
My lords, basically, appeal against appeal is not patentable. So far, Joseph Stephen's case is on different lines, on which I am ready to argue on subsequent time when he agrees. But it is not the case.
Let us call for the lower court.
Yes.
That would be required.
Only one thing I have to place, Your Lordship, from the judgment of acquittal, page number 40. Can you go to two lines?
40?
Yes, sir. 40. Last two lines, Your Lordship. Last 2-3 lines. From Exhibit 2, it has been, Lordship, got it. Further, it is evident from the Exhibit 2, the check return memo, that it does not bear the signature of seal, the competent authority of the bank, and thus the same is not considerable under section 146 of the NI Act. Further, from Exhibit 5, it is evident that it is a complaint raised by the complainant before the postal department by complaint number such and such regarding non-delivery of the legal demand. On that basis, that he has been acquitted by the appellate court. And the finding is, Your Lordship, at page number 46, para 10. He himself made a complaint regarding non-delivery of the item. That is not my document, Your Lordship.
that exhibit?
Exhibit 5, it has been mentioned as Exhibit 5, Your Honor.
Which
The
we have
complaint
annexed in there.
raised by the complainant to the postal department. And Exhibit 2 is the check return memo. 2 and 5 is the important.
Status report is article delivered.
Yes.
Lordship,
That is why.
kindly
Your
able to-
Lordship, let me place my case first,
Yes,
then I
yeah,
should
please hold
reply.
on. Please hold on, let me understand.
He is getting.
We will hear you, don't worry. We may not even hear you today, we will hear you tomorrow because LCR, unless I go through it myself, right? Only I cannot rely only on the assistant.
I'm saying, Your Lordship, 2 lines are pertinent.
Just let me just see where is the shoe pinching, right? It shows article delivered on 19/6/18.
Yes, Lordship.
13/6/18.
It is
In that regard, there was also a finding, Your Lordship.
13/6/18. Yes. Then what do you say that he lodged a complaint?
Lordship, that has been recorded in the judgment itself, Your Lordship.
That is why it is there in revision,
Yes, so that I have to check the Exhibit 5 from the LCS.
right? You check it right away. I'll post it tomorrow, right? The learned counsel for the
In
parties are present.
That on that regard, the finding is also there, Lordship, in the
So we will
paragraph
see the
10.
finding. If there is a perversity, then we cannot rely upon the finding of any of it.
Yes, Lordship. Regarding the delivery of the
Yes, we'll
consignment,
see what is
Lordship.
it. We'll see what is it. Because on the face of tracking report, it shows delivery on 13 of
6.
13.
I will check.
The learned counsel for the parties are present. The learned counsel for the petitioner has submitted that. The learned appellate court has set aside the judgment of conviction passed by the learned trial court on the ground that the
Complaint was premature.
premature and no definite date regarding service of notice, legal notice was mentioned. He has referred to Exhibit 5 and submits that Exhibit 5 is a tracking report of the Postal Department which shows the status article delivered as on 13/6/2018. The learned counsel submits that the including order is perverse and therefore it calls for interference. He submits that the matter matter be remitted to the learned appellate court for fresh consideration. Right? The records from the trial court has been received. Post this case for further hearing. 10:30 first case.
Yes.
Under heading for orders with effect, item 7, criminal division 461 of 2022.
This case has become infectious now, as because they have filed for against the discharge, and for the e-court services report, I got the judgment that the case has been disposed and the petitioner has been acquitted on 23rd of March 2023.
Criminal division number 461 of 2022. Nobody appears for the petitioner. the learned counsel for the opposite party number 2.
Pleading for the state.
On behalf of the state has submitted that the present case has become infructuous in as much as the status of the ST case number 8 of 2021 arising out of Nala PS case number 53 of 2020 dated 31/5/2020 registered under section 376 within bracket 1/120B of IPC has been ended in equitable. And in the present case, the order refusing to discharge is under challenge. It says that the present case has become infructuous. The records indicate that the petitioner had not appeared earlier on 8/5/2023 and had also not appeared before the learned registrar general as well as joint registrar judicial for removal of the defects. Considering the submissions made by the learned counsel for the state, so DLD.
But may I give the judgment in the second?
No, not required. Learned counsel for the state, this petition is dismissed.
Item 8, Criminal Division 939 of 2022.
This has also become infructuous.
Counsel for the petition, MSU submits that the present petition has become infructuous and therefore she does not know the basis. Considering the submissions, this petition is dismissed as not placed.
Item 9, Criminal Division 943 of 2022.
इसका status पता लग जाएगा? पता लग जाएगा? Nobody appears for the petition. In spite of repeated opportunities, the defects has not been removed. Time till 6th of March is granted to the petitioner to remove the surviving defects. Breakthrough. If the defects are removed within time, close this case on 14th of March.
Item 10, Criminal Division 957 of 2022.
Dispute is on clear. If the defects are not removed within the stipulated time, office is directed to prepare the order of dismissal within 3 days from the date of expiry of the time, and such order be immediately communicated to the court concerned on it.
3 weeks time.
It is not available.
Then I prefer only 1 day time also. I'm under impression that it is
All defects removed. Trial court judgment is not required to be filed. You have to rely on quality.
Yes. Item 11, Criminal Revision 962 of 2022.
In this matter, there is only one surviving defect, that is regarding filing of surrender certificate. Also, I have filed one IA application whereby I have seek prayer for exemption from surrender lordship. In para number 6, lordship, I mentioned the reason why I am seeking from exemption lordship. I read para 6 lordship. That it is stated that the petitioner for the first time was taken into custody on 7/12/11, and thereafter she has been enlarged on bail on 27/1/2016, that is BA number so and so, BA का copy लगाया. As such, she remained in custody for more than 4 years, and thereafter she has been taken in custody on 19/12/2016, that is on the date of pronouncement of judgment by the learned SDGM Tumka. The petitioner has been awarded total sentence of only 3 years, and during trial itself she remained in custody for more than 4 years. That the period undergone by her during the investigation and trial should have been set off by the learned trial court as well as by the learned appellant court, which has not been done. In this circumstance, the petitioner will be directed to. So, Lordship, I am seeking exemption on this ground that she has remained in custody during trial and investigation for more than the period sentence has been awarded. Your Ladyship, kindly allow me to place section 428 of the Code of Criminal Procedure.
Yes. What is the total punishment?
In the main application, kindly allow me to place last page, page number 41, last page of the brief. Para number 29. Under the facts and circumstances I discussed here above, and going through the records once again, I direct the accused, namely Elena Hasda, to undergo rigorous imprisonment of 3 years for the offence punishable under section 409 of IPC. And apart therefrom, she is further directed to make payment.
Pay the compensation amount, I give you it. You deposit the compensation, subject to the circumstances.
Will take instruction.
No instruction is
Because
required.
during we'll ask the client.
Who is for the state? When it comes to for the petition is present, IA number 1856 of 2024 has been filed, seeking exemption from surrender. The learned counsel submits that the sentence was modified by the sentence given by the learned trial court was only for 3 years with compensation, with the direction to pay compensation of rupees 2,68,000 in government's exchequer. And the petitioner has remained in custody for a period of more than 4 years during trial. Considering the aforesaid submissions, neither any counter affidavit has been filed in the present case, nor the state is appearing to oppose this interlocutory application. Considering the aforesaid submissions made on affidavit, IA number 1856 of 2024 is allowed. Let the records from the concerned court be called for by the office. You have straightaway, you have filed the appellate court's order.
दोनों orders हैं. From page number
Let this case be placed for final disposal on 7th of March 2023. then this order.
Madam, Kumari Rasi for the state, I will inform my lord. Kumari Rasi for the state, I will inform my lord.
So she is not there. You are not a proxy. It can't be
No,
like
Rasi
this.
is there another court, that's why I am.
I've already passed on.
All right.
Item 12, criminal division 968 of 2022.
Yes, petitioner.
2 weeks time to remove the defects. 2 weeks time to remove the
Same order. Reported PM. I'm granting you time till 7.
defects.
Kab din hai? 6th of March to remove the surviving defects. Surrender certificate ka defect hai?
No mercy. Limitation. Against acquittal.
Same order. It's a preempted time to remove for the state.
Item 13, criminal division 970 of 2022.
Some defect manner remove in the course of day manner. तो CCI सेंटर नहीं हम लोग को कॉम्प्रोमाइज के पास चल रहा है 2 weeks टाइम देंगे कॉम्प्रोमाइज पिटीशन फाइल कर सकते हैं.
No, I've given you the preemptive time to remove the defects, and if you want to file any joint compromise petition, you can file it and mention it before.
Yes.
It's NI Act
No, 498. Wife has been.
490.
1
Then you
year.
can file your joint compromise, ask your wife to be here and cooperative with you. And if you file any joint compromise, we'll see what is to be done.
Or some defect.
We have given you the time.
Item 14, criminal division 1001 of 2022.
9 कोई डिफेक्ट जो है हम कर देते हैं आज यहाँ पर कर देते हैं.
आपको कर दीजिए, आपको मना कौन किया?
और सेम मॉडल में इसमें भी कन्विक्शन है 3 years का.
Yes, petitioner.
हाँ इसमें हम भी हैं.
Yes.
इसमें सीसी ऑफ हम आई फाइल के हैं एग्जाम्पल.
What is the reason?
रीजन शफलिंग ईल में और डिफेक्ट हम रिमूव कर देते हैं 1 week टाइम.
What is the
आई फॉर एग्जामिनेशन पेशेंट.
what is it that you are suffering from?
Yes, sir.
What is it that you are suffering from? What is the disease?
Yes. हार्ट का प्रॉब्लम है हाइपरपेडिमिया.
What is that?
A disease caused by high level of fat particles in the blood. इनका prayer portion में लिखा हुआ है.
prayer portion में है.
Did you go to Vellore for treatment?
Yes, ma'am.
Where is that document?
Doctor certificate is there.
Where is that document?
Annexure 1. I have.
Annexure 1 is that
20.
you have been referred to Vellore.
Yes, ma'am.
Where is the treatment from Vellore?
Yes, ma'am. Treatment already undergone, ma'am.
Where is it?
One prescription, different prescription.
Vellore का
Vellore का तो हमको अभी मिला नहीं. हम
You did not go anywhere.
मांगा लेते हैं.
17/5/22 का जजमेंट है अपीलेट कोर्ट का.
और 24/8/2022 का हमको मेडिकल
जैसे अपील डिसमिस हुआ है.
Counsel, further parties are present. IA number 2080 of 2023 has been filed seeking exemption from surrender. The learned counsel for the state is directed to seek instruction and file a counter affidavit in the present case after getting the petitioner examined through a doctor to be appointed by the civil surgeon of the concerned district. Ab aap file karte hain. Rest of the defects?
हाँ मैंने डिफेक्ट और 1 week 2 weeks time. 1 week time.
So far as the other defects are concerned, the same be removed prior to the next date. आपका PS केस भी गलत लिखा हुआ है. आप काउंटर फाइल करो. आइए.
1 month टाइम.
1 month.
हम लिखेंगे फिर बोर्ड कॉन्स्टिट्यूट हुआ या
बोर्ड नहीं
किसी को
कॉन्स्टिट्यूट करना
या
है,
किसी
सिविल सर्जन
सिविल
will
सर्जन
appoint a doctor to examine the
इसलिए
petitioner
कुछ
and
टाइम तो
validate.
लगेगा.
ठीक है, कब तक वो सरेंडर नहीं करे, it's your problem, we do not know. How much time do you need? I think we do 1 year also.
That would look too much. 1 month sufficient.
Okay, pose this case on 21st of March 2024. The affidavit should be filed by 19th of March.
Serial number 11, my appearance, madam. I was here, madam. I was here at that time, madam.
Item 52, there is no reason why.
Then I have to record that you have no objection to the IA. I have allowed the IA.
2 weeks time maybe. 2 weeks time maybe.
Same order. 2 weeks, no, it is till 6th of March. All the orders are same, 6th of March.
Item 16,
It's a
criminal.
preemptory order.
Item 16.
You are the accused? Convict? Are you the convict?
No.
I'm asking you. Are you the convict?
Yes, my lord, I am appearing for the petitioner. This is
He has been convicted?
Yes, ma'am.
Surrender certificate is wanting.
I don't know that. All the defects will be removed before.
Because इसका surrender certificate वाला होगा तो same order.
Item 16, criminal revision 1031 of 2022.
1 week time may be granted for removing the defect. There is only one surviving defect.
So I'm giving you time till 6, same order. You are the convict?
No, I am the informant of the case. I have challenged 319, order of 319, filed before the learned trial court. Thereafter, that order I have challenged here.
What is the stage of the trial?
The stage of the trial is that in this case, altogether 7 accused persons were there. 2 of them has been convicted, 1 was acquitted, 3 have been summoned.
Same order और वो communication वाला भी है. Communication वाला सब भी रहने.
Item 17, criminal revision 1044 of 2022.
Bishop, this matter has been rendered infructuous now means the
Counsel for the petitioner submits that the present petition has become infructuous and therefore it does not want to proceed. Also for the opposite party state has no objection, but accordingly this petition is dismissed as not based.
Signed the Item 19, criminal revision 1062 of 2022.
Item number 14.
Yes, petitioner. Yes.
They should pray for 2 weeks time.
Same orders. Time till 6th.
6th.
It's in
6th of
item.
March. Preemptory order.
In serial 14, a copy of the order.
Copy of the order is all uploaded. We can't do this. You have no assistance to take out an. You go to the cyber cafe and get it. Yes.
The official media.
Item 19, criminal revision 1065 of 2022.
The surrender certificates have to be filed, so 2 weeks time.
Time till 6th of March. To remove the surviving defects, right? Preemptory order and same order, right?
Item 20, criminal revision 1092 of 2022.
Surrender certificate?
No. In this case, Union of India through the NCB has been filed also. When the matter has been some different also, and the one criminal rate has been filed, and Manga Singh and other person, entire case has been quashed, and the matter is maybe infructuous lordship, but the instruction is waiting. So just because we have filed on behalf of the NCB.
So you have to seek instructions?
Yes.
So I can post it tomorrow?
Yes.
Counsel for the petitioner submits that the present case might have become infructuous. She submits that the matter be posted tomorrow. Appropriate submissions will be made. Post this case tomorrow. Ensure to take it on mail, right? And keep it with you.
Item 21, criminal revision 1097 of 2022.
Petitioner.
Item 22, 1115 of 2022.
Same order claim.
Item 23, criminal division 1136 of 2022.
Also for the petition submits that the present case has become in practice and therefore it does not want to press it. Also for the small person party has no this petition is dismissed as opposite party.
Yes.
This petition is dismissed as not pressed.
Item 24, criminal division 1139 of 2022.
If you are a parents also, are you the advocate on record? On whose instructions have you made this submission? Assistant counsel to associate counsel to Mr. Chandrati. Yes.
Trying to meet standards.
Time till 6th of March. And order is paid.
Item 25, criminal division 1141 of 2022.
Same order.
Item 26, criminal division 1150 of 2022.
6th of March is the order.